Trust me, I want to get. You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.
Court of Florida is now in session. All who have cause to plead, draw near, give attention, you shall be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Good morning and welcome to the Florida Supreme Court. The first case on our docket today is Patrick versus the state of Florida.
Thank you. Good morning. May it please the court, my name is Rafael Rodriguez. I represent Mr. Patrick in this appeal from his conviction for first-degree murder and sentence of death. We've raised numerous issues on the appeal, but I would like to use my time to address what I think are the leading issues that require this court to take action, reversing the conviction, or at the very minimum, ordering a new penalty phase. The first and foremost issue, and in fact, is issue number one, is the jury selection issue. The gist of our argument on that is that a total of 8 jurors altogether were stricken by the court for hardship reasons. However, one of them was also stricken for death penalty reasons, without the defense having an opportunity to question that particular juror. So our position is on the long-standing jurisprudence of this court that when we deal with a death penalty, death-scrupled juror, the defense lawyer has to be given an opportunity to question that juror. And the record reflects that the trial judge specifically indicated that Miss Susie, which is what her name was.
Well, let me ask you.
Yes.
And again, I presided over a number of these cases, and that's always an issue. What typically happens is you ask to question the juror, and they said, I could never, ever, ever recommend the death penalty. And then the typical question from the defense counsel is, well, what about if Adolf Hitler was being prosecuted? Could you recommend death for him? And in most cases, jurors says, well, him I would. And then your response is, well, you see, there's someone you could, recommend death for. And that's what you're saying, that you should have been given the opportunity to come back up and see if the juror really felt strongly about that. But in this case, the juror involved, Susie, also had a hardship situation involved. I think she had some problems with children. What was it with her?
Well, Miss Susie, my recollection was her husband was a retired jeweler, and she had no children. But she apparently was the only income in the household, which the judge even questioned. I thought when you retired as a jeweler, you took the jewels with you, but be that as it may, she went ahead and struck Miss Susie without, but mixed it with her reasons on the death penalty.
Okay, let's assume for a second that, that juror Susie would have said, I have no problem with recommending death. Would the hardship position that she gave have been sufficient for the court to have just excused her?
We don't know, because the state was allowed to question her on hardship, but the defense was never allowed to question her on anything. The state questioned her, do you have financial hardship? Yes. There were 4 lines in a 1,200-page voir dire where the court asked Miss Susie whether there were any circumstances in which she could recommend death, and she said no. And then when it came down to striking Miss Susie, then the defense attorney says, well, we want to question her. He goes, no. She said death penalty, forget it. Besides, she has hardship. Well, you can't start mixing reasons, because then you implicate the due process argument in Rule 300B, which specifically says twice that the parties shall have their opportunity to orally question the jurors. Twice it says it.
Can I a question on that? Because I had never, in our cases, at least the death penalty cases that we've had here, seen as many hardship excusals. What is the standard for hardship? I mean, we certainly know the standard for cause challenges. What's the standard for hardship, granting hardship challenges, first of all?
Abuse of discretion.
No, but what is the, I understand that. What guides the judge's discretion? I mean, nobody, sitting on a death penalty case or sitting on a lot of cases are something that, although it's part of jury duty, I mean, citizens' duty, they don't like to sit often. So so people come up with excuses. So what's the standard that the judge uses in determining whether there is a hardship?
Well, the statute in question only talks about hardship. It doesn't really describe it for the court or the parties. I think what the judges...
And we have not ever defined it in case law?
Well, under the case law, they discuss certain things of what jurors have said, but they haven't said this is the standard. In other words, if someone says, I don't have income coming in, that satisfies the standard. And I think what's important is when you talk about abuse of discretion, that's fine. But if you're going to use discretion, then you have to be even-handed about it. And if you're going to let one party question the juror about hardship, you have to let the other party question the other juror.
Is a judge able to determine if the judge hadn't let the state question the juror on hardship, can the judge, without allowing questioning from either side, excuse jurors for hardship?
That's a very good question, Your Honor, because the case law is a bit silent on that. There is case law. For example, the Wright decision from this court is a post-conviction case, but that case dealt with the defense not objecting, and therefore there was a waiver and all these other things. And there's other cases that say, no, the judge can't delegate this to a clerk. There are certain sections of that statute that the judge himself or herself has to deal with.
You're not really, I mean, maybe it's because the area of the law is not clear, but I'm not getting a good sense about where our jurisprudence is on this. So if we're going to be addressing this issue in the opinion, whether we're affirming or would reverse, we ought to give clear guidance for the future. So if you were to give clear guidance, would you say yes, that no question that when it comes to hardship, that both sides should be permitted to question the juror?
I believe that if counsel asked to question the juror, because there may be a waiver, and he says, I don't need to question, I think that's absolutely clear, then under the rule, which also has constitutional ramifications by this court's jurisprudence, is due process involved, then the counsel should be allowed at least to question, especially where the other party has questioned the juror on that issue.
Did they ask to question each of the jurors that have been excused, or was there only one or two of them that they actually asked to question? I'm sorry.
No, there were a lot of jurors. In fact, the defense counsel, I think, was very helpful with the court, because look, on the jurors that we can agree on, we have no problem with striking them. So it wasn't like the defense lawyer was being obstreperous and trying to halt the proceeding.
How many of them are we talking about that
8.
that they specifically asked to question?
Correct. They were every single juror, with the exception of juror Gravel, who was never excused, and therefore he's out of the picture. But every other single juror in this matter, the defense requested an opportunity to question and objected when the court struck the juror, so that the record is preserved, the record is clear, there's no cloud on the record. And in particular as to Ms. Susie, I mean, the jurisprudence of this court is absolutely clear. There is no room for doubt as to what this court has said. When it talks about death scruple jurors, the defense lawyer has a right to question that juror. And when the trial judge used that as part of the basis, then the jurisprudence of this court clearly stepped in under O'Connor and Hernandez and Willacy and all the cases that we cited. And the fact that the prosecutor never questioned Ms. Susie on the death penalty is totally irrelevant, because this court in Sanders dealt with a situation where the prosecutor decided, I'm not going to question the juror. Your Honor's questions were sufficient to strike this juror, and the juror was stricken, and the defense lawyer, hey, so I want to question, I'm sorry, she's gone, or he's gone. So we believe that under this particular issue, that Mr. Patrick is entitled at the very minimum to a new penalty phase because of the death penalty issue.
Going back to the
Yes.
going back to the hardship part,
Yes.
and I'm troubled by the fact that the prosecutor was permitted to question the jurors and not the defense. But my question is there hardship in some occasion so obvious that that threshold is met without any need for further questioning? I mean, let's say a woman comes in and she says, I have a highly disabled child. He's outside in a wheelchair out in the hallway. My daughter took a day off from work today at the risk of being fired, so she can be out there with her. I have no one. There's no one can take care of her. Does the defense counsel really need to question her?
My gut tells me the defense counsel probably says, Your Honor, we have no objection. And
your gut does, but some will.
He did repeatedly in this record. He agreed to that. But I give you two examples. Ms. Hughes, the teacher.
But before you do that,
Yeah.
I mean, my question is there something so obvious? Put it aside whether a good lawyer, obviously a good lawyer would not even question that, but some lawyers will. Is there a hardship so obvious that the court can handle it without giving both sides an opportunity to ask questions?
Well, there is case law that general qualification before the parties even get into the courtroom, the court may deal with that on an issue. But the situation changes when the parties are present and questioning begins. So in that situation, if defense counsel wants to ask one question, I don't see the problem with judge says, all right, go ask your question. It's going to be probably going to be the same, and the record's going to be clear. But there's no, you're not throwing sand in the wheels of justice here by allowing the defense counsel to ask one or two questions.
Well, but so let's go to the practicalities here. And you may say that if the result is the same, somebody, and I guess let's talk about cause challenges, and I want to make sure I know on those our jurisprudence is clear. The jurist says, I know the defendant. I was a victim of a scam by the defendant. I mean, hopefully that's not said in front of everybody. And I also, the way I see it, anyone that is that kills another person automatically gets the death penalty. But there's those, would there still be reversible error if the judge didn't allow either side to question the juror where one side or the other requested it?
Well, if he said that in front of the panel, I would move to strike the panel. But assuming it's individual questioning, if the judge premises his or her decision partly on the issue of the death penalty, I don't think there's room in the jurisprudence of this court for any doubt as to what has to be
But we
happened.
don't have a standard, I don't think, because you're saying, well, let's give a new penalty phase. If the process has been violated, if something in the process has been violated, there isn't, unlike a harmless error thing, we're not saying, well, it probably didn't affect it in the guilt phase. I mean, you would have put her on in the penalty phase. We don't do that. So your idea that we could just, if this is error, structural error, that we could just reverse the penalty phase, I'm not seeing how that would even happen and be true to our jurisprudence. Can you explain how?
This court has said that where counsel has not able to question a juror on death, when death is used as an excuse, you're entitled to a death penalty, new death.
So you're saying we've
penalty.
made that distinction?
Oh, absolutely.
Okay.
Hernandez, Willisey, Sanders, O'Connell. I mean, the cases are
on
there.
the hardship, you were how many hardship requests were or decisions were made where the defense lawyer agreed to them?
Numerous.
Well, like 10? 20?
Yeah, more than 10. I mean,
So
the record is replete. He wasn't trying to
So there were
hold the
lots
proceeding.
of jurors
Yes.
that were excused for hardship.
Yes, and in fact, defense counsel on some of them agreed to the striking of jurors for death penalty reasons. The record is clear on that. But when he said, I want a question, that's a whole different standard.
And what was the reason the judge gave for not allowing the defense lawyer
She
to
didn't
question?
really explain, except to the extent she says, well, if we're letting other people go for these reasons, I'm not going to keep her here. And she repeated that over and over, and she made references to the bad economy and because people need jobs and all that. And I'm not questioning, that that's not rational or reasonable, but I am saying that once she mixed the two, that's a different situation. And I wanted to address...
It's only as to the one juror and not to the 7 others?
Oh, no. I wanted to bring to the court's attention at least 2 examples. Miss Patricia Hughes, the substitute teacher, who said she had issues about a substitute teacher taking over. The court asked her point blank on page 90 of the record, but you could, if the lawyers picked you could do this. And Miss Hughes says, yeah. I mean, the record is clear. And that's one of those jurors that the defense counsel wanted to question and was not allowed to do that. Mr. Johnson was another individual. He was semi-retired. He had issues with his mother and his wife being ill. And the court asked, could you do this? And the prosecutor, asked, you could do this? And says, well, I could do it definitely without a doubt. And then proceeded to give some questions about issues about his family. When you have a situation like that, the defense attorney should be allowed to question these jurors, especially when the other party gets a chance to question them.
I'm trying to think of the issue of manifest error. Was there any argument made below that the jurors who actually served on this panel were not qualified? I'm looking in the area of error, harmless error, or whatever.
Not qualified in what sense?
Well, was there any argument that the jurors who actually were sworn in and decided this case were in some way or another not qualified to serve, that we were stuck with this jury?
Well, defense counsel raised nil objections. They were adequately explained in the record, and we didn't raise that as an appellate issue here. There were issues about cause challenges. Again, the record, I think, was pretty clear that there was a basis for it. So there were indications from the defense that they were not necessarily happy with the panel, but I can't say they were necessarily unqualified. What I can say is leading up to that, there were these other issues. And so I can move on to the next issue. I just want the court to be...
Before you do,
yes.
Let me just clarify for my purposes, were there any jurors that were stricken for cause, not related to hardship, but that were stricken for cause that the defense was not allowed to question?
Well, there was the only one that was stricken for cause was Miss Susie, in the sense that the judge says, forget it, she's out of here. She said death penalty never. I mean, that was pretty clear on the record when that happened. And I think the record is page 279. The court says, Miss Susie, the prosecutor, cause. The court, what's the defense position? We need to speak to her, at which point the court gave the reason. So there was a cause challenge granted to the state on Miss Susie, and then she proceeded to say it was a death penalty.
For reasons totally different than hardship?
Well, she mixed the two. I'm not going to say that the court based it exclusively on that. The record is clear that she mixed the two, but she repeated it twice. She said death penalty never. At the end, forget it. She said death penalty never. Those were the court's words. Now, the other issue that I do want to address, which I think is very important, and that is the issue of the defense lawyer not being able to establish a record as to the victim's habit of bringing men to his apartment for sexual favors. Normally, I agree, that's irrelevant, okay? And the defense lawyer admitted that. We're not here to attack his character. But this is very important in the context of this particular case. The reason that was important is because the state, through its witnesses, made it an issue that Mr. Patrick targeted the victim at the very moment he met him. Through the testimony of the flip, Mr. Dietz, through the introduction of the defendant's statement. The court used that as part of the CCP finding for imposing the death penalty. She specifically, in her order, I think it's 963 of the record, made reference to Dietz's testimony that the defendant specifically picked out the victim the moment he met him. And Mr. Dietz testified that this is what the defendant allegedly told him in the jail, and he then came and testified in court. Therefore, our position and the defense position below was that it was relevant because it did several things. it would have enabled defense counsel to attack the issue of premeditation. It would have attacked heightened premeditation for CCP. It would have corroborated his own statement where he says, I didn't target anybody. So what the court did was, I'm going to exclude this, and yet the court used it in part on the CCP. In my view, it's a Gardner violation in the sense that she used something to impose the death penalty, and defense counsel was never able to address it, either before the jury or anywhere else in the record. So in this particular case, in the unique facts of this particular case, we believe that the defense counsel should have been able to bring that information out, because it was repeated. The prosecutor in closing argument mentioned targeting. Targeting. And they, in fact, brought the issue into the courtroom by placing Mr. Dietz on the stand and introducing the statement. The statement was partially redacted. Mr. Dietz's statement was partially redacted. But those things are in the record.
This system, what you describe is what's called cruising, apparently?
That's what the trial court herself called it. Yeah.
And apparently the victim and your client met at a park.
Correct.
Am I correct? Which is typically known in the area for that type of activity.
Correct.
Right. However, the actual homicide, excuse me, there's a cell phone on. The actual homicide, in this case, occurred like 2 days after your client met the victim, in this case, at the park. A week after?
Yes, a week.
So doesn't that, in a way, kind of dilute the whole point of you bringing out this whole cruising?
Well,
the relevancy
and
of
the prosecutor made that point in closing, says, look, you could have premeditation at the beginning, you could have premeditation right before, you can have premeditation, halfway through the week, whatever. But she says, but you can have premeditation from the beginning, as Mr. Dietz testified. If you're going to make it an issue, and if you're going to premise your argument on that, then for heaven's sakes, let the defense address the issue.
Well, how would the knowledge that the victim, picked up men for sexual favors, how would that negate or even help explain whether or not the defendant had the premeditation at the beginning and actually targeted the victim? How would that change or even explain or do anything to help the jury understand whether or not Mr. Patrick had that premeditation?
Well, I can give the court a reason, and that is that Mr. Schumacher, who was the victim, according to the proffer that was made, so we have a record, would have this practice of doing this.
He would have a practice of picking up men in the park.
And for sexual favors, and that's in the proffer. Ms. Scott and Mr. Lyon testified to that in the record. That was excluded, but the court allowed the proffer to occur outside the presence of the jury. Mr. Patrick, in his statement, adamantly denied that he targeted Mr. Schumacher. Adamantly. And in fact, the detective, Nicholson, says, well, maybe I used the wrong word, targeting. It was obvious from the questioning that the detective was building a case of premeditation. But be that as it may, by introducing that, it corroborated Mr. Patrick's confession, where he says, look, I didn't target anybody. I didn't target, and in fact, I reacted when Mr. Schumacher attempted to anally penetrate me. So it was also an explanation of who was the aggressor at the time. It served various purposes as to what was occurring here. We had a somewhat sanitized version that was given to the jury of a completely innocent victim. Now, he was an innocent victim. We're not condoning what happened. But you have to give a complete picture of what was happening here. Mr. Schumacher actually, according to Mr. Patrick, picked him up. And it was consistent with his habit of doing that. And the defense lawyer should have been allowed to introduce that evidence. Whatever weight the jury wanted to give it, that's a whole different question. They may have just rejected it out of hand, and that would have been the end of it. But to completely close the door on that type, I think materially affected the defense and materially affected the CCP factor, which the court made reference to.
So there's nothing in this record, all of the evidence that indicates that that the victim picked up men was excluded?
Yes. The only thing that was brought out was that he was homosexual. That was brought out.
And how was that brought out?
In Mr. Dietz's testimony.
In what? So what was the extent of?
Mr. Dietz testified that the defendant told him that he knew Mr. Schumacher was homosexual, and that he's indicated he led Mr. Schumacher to believe he was also homosexual because he targeted him from the beginning.
So it was really came out as more of as an admission by the defendant as opposed to it being something that could be developed by the defense.
Right, it came out from the flip. The person in the jail who flows out.
But that was something that the state wanted to introduce as to how this happened.
Oh, absolutely. In fact, Mr. Dietz, in our view, it was a star witness. In fact,
I mean, the jury could have disbelieved that he was that Schumacher, Mr. Schumacher, the victim, was a homosexual, because there was nothing.
There was nothing else to back it up.
So there was nothing else to know. That,
right.
So it would be much more. I mean, again, it would be much more likely the jury would say that this is just something that the defendant's making up.
Well, yes. I mean, and that dovetails with the fact that the defendant in his confession says he tried to, sexually assault me. So, out of the blue, all of a sudden, this man is sexually assaulting him. I mean, the jury's going to say, where did this come from? There's no support for his statement unless we're allowed to introduce that evidence.
And this was a 7-5 jury recommendation.
And it was 7-5. So even in this situation, we have a borderline recommendation for the death penalty.
Counsel, you're now down to about 4 minutes of your total
Okay,
time.
well, then I will wait for my rebuttal. Thank you.
May it please the Court, Lisa Marie Lerner with the Attorney General's Office for the State of Florida. And I wanted to address the jury issue and just clarify factually what happened. These 8 jurors, 5 were excused on the first day and 3 were excused on the second. On the first day of jury selection, in the afternoon, the court called counsel aside and said, I've done hardship, and the court did a general hardship finding and said, I want to try and get some of these hardship people out so they don't have to come back tomorrow and be inconvenienced. Is that agreeable with the parties? The parties said yes. So the court finished its questioning, then allowed the prosecution to start questioning. The prosecutor on these 5 jurors at issue on the first day did not ask any of those jurors any questions other than hardship questions, because these were the individuals who had told the judge that they could not serve for legitimate reasons, and I can go through the reasons.
But to those 5, did the defense have an opportunity to question them?
Well, this is what happened. The prosecutor finished questioning at 4:50. The court then told the defense that it could begin its voir dire, and the defense would have had a chance to question anyone they wanted. The defense attorney stood up and said that he did not wish to start because he didn't want to break up his voir dire. The court said, are you certain? Because I want to get these hardship cases out. The defense attorney said yes. The court went through a colloquy with the defense attorney and took a waiver of him questioning these people before he left. The court then did a colloquy with Mr. Patrick, saying, is it agreeable with you if we dismiss the hardship cases without your attorney questioning them? Patrick as well said yes. It was at that point that the court began its discussions with the parties about the hardship cases. And I disagree with counsel here on one point. The defense attorney only asked to question Ms. Soucy. He did not ask to question the other 4. The other 4, he merely said object for the record. He did not ask them to be brought back.
Was Ms. Soucy on the first day?
Yes, ma'am.
So are you saying there's a waiver as to all 5, including Ms. Soucy?
Yes, although I do say that the defense counsel asked Ms. Soucy to be questioned and for her to come back the next day. He did ask that, but he did not ask that for the other 4. And on Ms. Susi, she plainly said multiple times, she interrupted the judge a number of times in his general questioning, explaining that she had a hardship, she couldn't be there, she wanted to leave.
And what was her hardship was?
She was the sole income for her family. If she didn't work, she didn't get paid, and they could not take that financially, which is a classic hardship excuse. She also, in the general questioning with the judge, in terms of raising hands, who had strong opinions pro-death penalty, anti-death penalty, she said anti-death penalty never. She volunteered that. The court didn't ask her that.
Do you know offhand how long it took to try this case?
I believe the voir dire was, 3 days. The whole case was about 2 weeks, and the maybe a little less. And the penalty phase was several months later, so there was a break between the guilt phase and the penalty phase.
Well, the guilt phase was about 2 weeks and a half
Yes.
long. So that's something a judge would take under consideration as far as hardship or financial reasons is concerned?
Absolutely. And actually, this court's case law, hardship is generally a qualifying question session where judges often do it outside the presence of the attorneys or in the presence of attorneys, but don't allow the attorneys themselves to question because it's a general qualification. And this court, in its cases in Wright and Ramella, have indicated that there's a difference between whether or not a jury is generally qualified, i.e., does he have time, physically able to do it, as opposed to qualified to sit on a particular case. And this court has distinguished those two different types of qualifications.
Have we ever, obviously we're in very tough economic times, and certainly South Florida is no exception. Have we ever enunciated, any standard on the economic hardship, which would seem at its outset to be would tend to excuse jurors who are of less income than those with more income, independent income, especially in a death penalty case, skew the jury in a certain way? Has that, because again, this is the first time we've actually, in my recollection, talked about the hardship exception, at least for jurisprudential purposes, and that just seems like a concern that if it was done outside of the presence of the defense and prosecution, it could lead to a skewed panel.
There's no case law that I found on it. I do know that many employers will pay their employees while they're serving on the jury, but the problem does come in, as Your Honor pointed out, for self-employed people, like some of the potential jurors here.
But of course, what we know is this, even for the circumstances, and this usually comes up in a cause challenge, where somebody, their employer is going to pay, employers aren't thrilled to have that occur either, and you see cause challenges where a juror is trying to figure out every which way to get off the jury because they know their employer is not going to be, unfortunately, happy to not have them for 2 weeks. They're an important part of their organization, so there's that as well. So would you say that, though, that we would announce a rule of law that would say that hardship questioning can be done outside of that was my first concern, outside of the presence of either the defense lawyer or the prosecution?
This court, I believe it was in Ramella, referred back to a second DCA court that did allow that process.
So you're saying yes, that a judge is perfectly fine?
I think that I'm not saying it is perfectly fine. I'm saying this court has said in the past that certain jurisdictions practice that.
Well, the process that I'm accustomed to is that the duty judge that week will go down to the jury panel room where the big panel is, and the folks who work there, the clerk's office, will line up the people who claim to have hardship, and the judge will meet with them alone and hear their hardships and decide whether they should be excused or not. So that is done before they come up to a courtroom as members of an IR in a particular case. And that's the practice in Palm Beach County. Are you saying, do you see any legal problems with that? That because you are, in a way, doing below what counsel claims cannot be done in the courtroom?
Yes. I don't see a problem with that because it's the judge's discretion to determine whether or not a hardship claim
Why
is
shouldn't
valid.
that process, though, be limited to certain statutory grounds as opposed to just any broad type excuse? This has far broader implications than just this one case. If we announce a principle of law that begins to approve sanitizing juries before they even reach a courtroom, I can see grave danger in that type of process. And I mean, for 30 years, that's the way a lot of these things were done, and they were done before they reached the courtroom. So I think the question is now being posed to you, is that something that falls within the parameters, particularly in the death case, of due process, of equal justice?
Well, on the larger issue, Your Honor, that is something this court's going to have to decide, but that's not the situation that occurred in this particular case.
The point being, you're going into no need to question, you can't question, go ahead and send them home. I understand the practicalities, and many times the practicals override what may be the ideal, because it's tough to get juries. I mean, I've seen that happen, and even having enough jurors. But the question to not permit one of the parties to participate beyond, as I say, the statutory grounds, those are objective standards, are they not?
On hardship and whatnot?
We have statutory basis for which you can be disqualified, correct?
Yes.
Okay, those are pretty objective, are they not?
Yes.
So it gets to the gray area where you need the questioning.
Yes, but that's on a case-specific questioning. And the state's not saying that both counsel should not be able to question potential jurors on specific issues.
But what I'm asking, let's take the substitute teacher. If that were done by the judge before the start of the morning activities where neither side was there, and the judge said, "You're a teacher, yeah, but I really don't want to have a substitute," and say, "Okay, I find that to be a hardship. Excuse the juror." That's permissible? I mean, again, I'm not talking about the example, Justice Labarga's example of somebody that is, somebody that I'm the caretaker for, the sole caretaker, which is, again, it seems like objectively different. So how about take the substitute teacher? Is that something that can be done outside the presence of either the prosecution or the defense?
Well, it would depend on if the judge interviewing her, someone like that should probably be in court.
How do we, if you say hardship can be done by a judge, a duty judge, in a big courtroom downstairs where everybody is trying to get off the jury, then there's no measure, objective measure, as to what is the hardship. We would have to say that is all okay. How would you decide the substitute teacher is different from the retired jeweler?
Well, there was additional questioning on Ms. Hughes.
No, I'm talking about if we're saying that it can be done without either side being present.
Well, my experience is some of the Justice Labarga, what happens is the juror is being, Venari is being qualified by a duty judge away from the court, away from the attorneys. No attorneys are there. You ask them the basic questions in terms of age and et cetera, and those other hardship disabilities. And I normally ask the jurors whether or not anybody did not answer a question, that they felt embarrassed and they wanted to talk to me outside of the other people. And I go back to the room, I wait 5 minutes, and they come, then they give me their story, and then at that point, the judge determines whether or not there's a hardship. In most instances, we don't say there's a hardship, but in some instances, we do. That's the way it's done. And we don't even get to whether you oppose to the death penalty or not, because we don't ask that question. That question is asked in the courtroom.
I guess I was, I don't know what, this may be done. There, as Justice Lewis says, there are a lot of things that are done for expediency that the court doesn't know about because it's not on the record. And this is extremely concerns me, and it may not be the issue here, but it seems that if it is fine to do hardship questioning and use discretion broadly outside, that would be then you're okay. Now let's talk about juror Susi. Because certainly somebody saying for cause, I'll never impose the death penalty, or I know the witnesses, can that be done outside the presence of the lawyers as well?
No, because that's qualifications particular to a case.
Okay, so what is the standard if, let's just take that Susi doesn't have the hardship. Let's take that out of the equation. And the defense lawyer asked a question on a cause challenge, but it's obvious because to the judge and everybody that this is somebody that is against the death penalty. Is it reversible error to fail to allow a defense lawyer to question the juror on some juror that's going to be excused for cause?
Yes, Your Honor. Under this court's case law and the statutes, O'Connell and the Hernandez and Willisey, they all point to those courts exercising a double standard, and that was the basis of those cases being reversed, because the courts in those three cases allowed the prosecution to question the potential juror about his or her views on the death penalty, but refused to allow the defense to do so. And this court specifically said in O'Connell the issue was the double standard employed by the court. And in Willisey, this court said that the juror who was excluded was completely anti-death penalty. She was properly excluded but reversed because the court had failed to give the defense a chance to rehabilitate her.
Now let's talk about double standards. So if Judge Holmes had seen the questions on the jury questionnaire and in general questioning this juror had said, I'm against the death penalty, could the trial judge, without allowing either side to question the juror, excuse the juror for cause?
No, because it's qualifications for a particular case.
I thought you said it's double standard.
No, the double standard was allowing one side to question without allowing the other side to question.
But you agree that even if no side is allowed to question, that it's reversible error?
Yes, if the court does it on its own, on the issue of death penalty or something like that.
So how is, for juror Susi, since the judge did not, if we take and accept that the hardship is different, how do we, with the judge having said, I'm doing it for both reasons, she can't be fair on the death penalty, how can we sustain that? Because
the judge, she essentially, she said that I'm going to quote what the court said. She said, death probably never, and losing money, and her family can't take the hit. I'm going to exercise my discretion. I note your objection, but if I let everyone else with the same rationale go, i.e., not having income, the judge is throughout this voir dire trying to be consistent on her hardship rulings. She goes on to say she's got the same. If this were a different economy, nobody would be leaving this panel. But with people not getting their jobs and jobs being lost, don't want to have that on their mind. And that was with Susi. So clearly, the basic reason that court released Ms. Susi was because of the hardship. The court also acknowledged her anti-death penalty reasons, but the basis for the cause challenge was the hardship. And that hardship existed, and even if no questioning on the death penalty had happened, Ms. Susi would have been released. The prosecution did not question her on anything regarding the case or the death penalty. So we don't have a situation, as in the other cases that we cited, where one side got to question on the death penalty and the other side didn't.
What about this cruising issue he raises?
The trial court said it was irrelevant and would inflame the jury. The defense wanted it in because they wanted to negate the fact that Patrick was the aggressor. Now, the court correctly pointed out that whether or not Mr. Schumacher in the past would pick up individuals, some he might have had sexual relations with, others he did not. That was the proffer. And that he would help people down on their luck. So it wasn't he just picked up people for sex. The proffer was he picked up people to help them. Some of them he had sex with, others he didn't.
Well, why would that be excluded?
Because it was
that's not objectionable. That's not a more prejudicial than substantive here.
Well,
if that were the case, I mean, I think clearly the case was that they wanted this kept out because that information outweighed its relevancy. Isn't that what the ruling was?
The ruling was twofold. It was irrelevant. The court found not that it was more prejudicial than probative. The court found it irrelevant. The court also...
How can that be when the state is taking the position that this is a CCP case? Without CCP, I mean, it's even arguable whether this is a death case. And with the CCP being there from the outset and saying that this is targeting is one of the key elements for the CCP. It's not somebody breaking into a rage. And why, if the state can take that position, you can't tell the jury the truth, and the jury is then sanitized what the truth is?
Because Mr. Schumacher's behavior in the past was not relevant to his interactions with Mr. Patrick, because even if Mr. Schumacher went to the park that day to pick someone up, that does not negate the fact that Mr. Patrick could see Mr. Schumacher picking him up and take advantage of him and plan it from that day.
So what you're saying is that this works in reverse. It only works against the defendant. That we can use whatever we can from this to the prejudice of the defendant, but we cannot then turn around. I thought that there was already coming into evidence facts with regard to homosexual activity between Patrick and this victim.
Yes, it came in.
So that was going to come out anyway.
Yes, it came in through Patrick's statement and Diaz's statement.
So I'm missing why the judge said this is not relevant at all. It wasn't on the basis that the prejudice outweighed the value of this?
No, he said it was irrelevant. The reason that the defense articulated at trial was that they wanted this in to show that Schumacher was the aggressor, and as to sort of a self-defense, a reaction because he was aggressive. None of the other evidence was indicative of him being the aggressor. The fact that he picked up people in the past did not show he was aggressive. And that was the basis the defense wanted this in. The court also pointed out that this did not provide a valid defense for the crime itself, which happened a week later in the evening in the bedroom.
You don't have evidence does not have to be a defense to the crime before it's admissible. You certainly would agree with that.
But it has to be relevant to...
Well, I agree, but I mean, what is relevant?
Well, this wasn't, because...
Well, I mean, what is the definition of relevancy?
If it goes to prove a fact in the case for...
And you've got a defendant trying to save his life, saying this is not CCP, or his lawyer trying to prove this is not CCP, was not targeted from the beginning. It was the victim who was targeting this defendant. And then you get into the rest of the scenario, and even the beating. The beating, to me, seems like a frenzy rather than one of these cold, calculated, premeditated, the typical CCP case. Was this not just a frantic beating site from the evidence?
No, from the evidence it wasn't.
The teeth, they didn't find teeth there, and a box was used, and it was on the bed? This was not found? And
yes,
blood
but
splatter everywhere?
But, Your Honor, there was also ample evidence of pre-planning and calculation.
What was that?
That came in through the fact of Diaz's statements and...
The jailhouse snitch was the only evidence of this, correct?
Yes.
If you look at the physical evidence at the scene, it was a frantic beating, was it not? I mean, legitimately, for a lawyer looking at this scene with teeth everywhere, with blood splatter everywhere, with boxes being used, with blood all over the apartment, wouldn't you look at that and say, wow, this was not one of these shoot them with a bullet while they're sleeping kind of case, was it?
No, but the case law on CCP also goes to the type of injuries and the relative amount of force used. And that shows CCP, the very...
Which element of CCP is amount of force used?
For example, the...
which elements? Only you can give me the examples.
The cold, for example. Patrick, in his confession to the police, it was a self-serving confession, but he did confess, for example, that Mr. Schumacher repeatedly asked him to stop beating. And so Patrick told the police, yeah, I stopped beating him for a while, but then I went back and started again. That contradicts his theory that it was a rage and frenzy. Patrick
what was the cause of death?
It was blunt force trauma to the head and strangulation by crushing. This was not manual strangulation. Apparently, he either stomped on his neck or hit his neck against a hard object.
And now, in the circumstances in which the body was found, the victim was hogtied. Is that correct?
Yes, the victim was first on the bed. There was a tremendous amount of blood on the bed. Then Patrick moved him from the bed to the floor. The beating continued on the floor. It was not continuous. The testimony was that the forensic criminologist said the body was picked up and put down. It was not dragged. And then the beating continued on the floor.
When he was hogtied, and I believe he also taped his head and just left out the nostrils?
Yes, and he put
but at that time, wasn't some evidence that he knew that the victim was alive at the time he left them there hogtied in the bathroom?
Yes, and the way
the victim probably died sometime later after the defendant left.
Yes, but we also know that by Patrick's statement, by the medical examiner's statement, and by the forensic evidence, that Patrick folded up or wadded up a pillowcase and put it in the victim's mouth and then taped it. And Patrick said he did that. He had to break in the beating to do that because he was tired of hearing the screams and the begging for his life.
Everything that you have described in the last couple of minutes shows that this is a heightened HA, from my point of view, a very graphic example of what we mean by HAC, heinous, atrocious, and cruel. More so than many other cases, from my point of view. But I think we were getting back to, this is a 7-5 jury recommendation. We don't know which aggravators were found and what the reason is for the 7-5 recommendation. It sounds, based on what you've said, you would think it would be unanimous that this is a death penalty case.
Unless there was anti-gay sentiment on the jury.
What I want to go back to, though, on CCP, I thought that what we were really dealing with is whether if the state had used the way the crime was committed and the length of the attack for the CCP, that would be one thing. But I guess I thought, and I need to go back at the judge's sentencing order, that the judge relied and the state relied on the heightened premeditation from the point when Patrick met the victim. Is that correct or not correct? That's just a yes or no. Did the judge rely at all on the circumstances in which the defendant first met the victim?
No. The court relied, and the state argued that Patrick premeditated this. The state argued it could be from when he first met him, it could be a couple days while he was staying there.
Okay, so the state argued that the judge did not rely on that in the CCP finding?
The court relied on the fact that Patrick told Diaz that he planned the killing, and Diaz testified to that. There was also testimony both by Patrick through his confession, the physical evidence, and Diaz had no access to the physical evidence. The fact that while Mr. Schumacher was hogtied, either in the bedroom or the bathroom, I don't know, Patrick went and packed himself a lunch and created an alibi. Patrick told Diaz that he created that alibi beforehand. He cleaned himself up, he went and packed a lunch, he drove the truck over the Tri-Rail station, left the lunch there, left the truck there, and then buried the keys to provide himself an alibi. He had also turned down the air conditioning to so that the body wouldn't decompose so quickly, so that if he were questioned on this, he could say that he was at work, he had a welding job that Mr. Schumacher helped him get, and that he was at work when this killing occurred, so he had nothing to do with it. The fact that he went through the process of creating an alibi, having it ready, and then going through with it goes to CCP. And the court relied on that as well. The court
the judge relied on that the defendant cleaned up the scene afterwards. Do we have cases that are emphasize what happens afterwards? You know, if there's a frenzied killing, and then afterwards the scene is cleaned up, is that CCP?
Well, I can't answer that question right now. I will research it. But it wasn't just cleaning up, because Patrick had told Diaz that he planned this and planned the alibi, which is why he took the welding job. That's what he told Diaz. And it corresponds to what the police found. They found the lunch in the truck, and Patrick also admitted the truck and the lunch to the police. The court also specifically relied on the fact that he had created this alibi beforehand. If someone is in a rage and a frenzy, you don't have the wherewithal within minutes of killing to create an alibi this wonderful. I ask this court to affirm both the sentence and the conviction.
Very, very briefly on rebuttal, as far as the jury selection, the court over and over, Ms. Hughes, whether you object or not, I'm overruling your objection. Ms. Fernandez, whether you object or not, she's going to be stricken. As to the other jurors, specific requests.
Now, it seems to me that your opponent's argument wasn't that there was no objection, but that there was no request or actually to question these people, but there was an objection.
I think that
is there a difference here?
Yeah, the gist of their argument is that there was some kind of waiver, but there wasn't any. In fact, the
waiver of questioning, not waiver of dismissal, but the waiver of questioning.
Well, waiver of objecting to the procedure used by the court.
But on that, if there's really hardship, let's take Ms. Soucy out of it. If there's really hardship and the judge is saying, I don't want to have these people have to come back another day, and the defense lawyer says, well, I'm not going to start my questioning at 4:50. The defense lawyer couldn't have said, please let me just ask about hardship as to these 5 jurors? Is what Ms. Lerner said correct?
Well, in the record on page 187, the court says, I've got my list, and Ms. Tate, at about 4:30, I'll stop you again and give Mr. Reeves an opportunity. I'll let everybody that I'm bringing back tomorrow go and tell them what time to come back. So what the court was saying is, it's already almost 5 o'clock. Let's get rid of basically who we can agree on, and I'll bring everybody back, which is what the court had repeatedly said earlier in the record. I'm going to give you an opportunity. I'm going to give you an opportunity. Even when the jurors were talking about hardship, she goes, I'll let the lawyers question you about this. The defense lawyers were being led to believe that all this was going to happen, and then whammo, when the moment came, she goes, whether you object or not, these people are gone.
But you still, I think, have not answered whether or not, when it came to it, and did the judge say they could start their questioning, and then the defense then say they didn't want to question them on that, or not?
Well,
I mean,
yes, but what happened was at the time of day, they said we can agree to excuse the people that we can agree on, and we bring everybody else back. And that's what happened. And then in the next day, there were specific requests to question the jurors that went before they were stricken. Miss Guerrero, Mr. Johnson, Mr. Mason, all those on the record indicate.
That's the second day.
The next day, I want to question them. Sorry, they're gone. So the record is clear that those questions and answers were given.
But so, I guess the question in my mind becomes whether or not the defense on the first day, when she was about to let these people go, could not have said, Judge, it's 4:50, it's going to take me a while to question them. I still want to question them about the hardship.
Judge, I think the record is going to reflect that one of the attorneys, Ms. Ferraro, who was in charge of death qualification, was ill. And she says, and the judge took that into consideration in recessing for the day. That's what the record's going to reflect, that there was some physical problem with Ms. Ferraro. And I think if you read the entire record, you will come across with that information, that there was an issue about that.
I want to ask, how do you rehabilitate a person based on hardship?
Well, for example, Ms. Hughes, who said on the record, I can do this, but I'm concerned about a substitute teacher, but if I get a substitute teacher that is consistent, I don't have a problem.
Right. But how about the self-employed plumber who comes in and tells me, I am the business. You keep me here 2 weeks, I'm out of business. There's no one else. How are you going to rehabilitate someone like that? What are you going to say?
I'm not sure what
you have a savings account you can live off of for 2 weeks? That's the usual.
Counsel may ask him, do you have anyone that can assist you? I don't know what the question would be.
He just said that. I have no one else. It's me, myself, and I. No one else. What else can you ask? Why can't the judge just make a determination right there on the spot? You know, this is a hardship. If he can do it down beneath in the jury room before they bring him up.
And why can't the judge, and when these people are out in the hallway, says, come on in, let the defense lawyer ask a question. One question. They're outside. It's not as if they have been excused and then the judge is handling this issue. They're all outside. And I've been in situations where the jurors are brought in for those specific types of questions. So, you know, the record reflects that that's what the situation was. There may be situations where it's so obvious, but I have to tell you that once the state is given an opportunity, once the state was given an opportunity to question the panel on death penalty, including Ms. Susie, and the hardship, then they have even-handedness has to go toward the defense.
That I understand.
Thank you.
We thank you both for your arguments. We will now go to the second case on our docket, Blackman versus the State of Florida.
May it please the Court, I'm Gail Anderson, representing Mr. David Blackman. Mr. Blackman's case is here on a certified conflict issue between the 1st DCA and the 4th DCA. On that issue, Mr. Blackman asks that the Court hold that when a jury finds a defendant guilty of both theft and dealing in stolen property, contrary to Section 812.025, that the proper remedy on direct appeal is to order a new trial. Mr. Blackman also asked that the Court exercise its discretion to address the second argument presented in his brief and hold that when a defendant presents a reasonable hypothesis of innocence for which the State presents no facts in rebuttal, the inference of guilty knowledge arising from the recent possession of stolen property is insufficient to support convictions or probation violations based upon theft, dealing in stolen property, or burglary.
A number of district courts have followed the procedure used in double jeopardy type cases, where if a case goes back, it should be the highest possible crime charge that stays, and the lowest crime is thrown out.
Yes.
Why isn't that possible here?
Well, it's not a double jeopardy violation.
Well, it's the same principle. That's what is claimed.
Well, the simplest answer to that, Your Honor, is that there's a specific statute that has very clear language saying that the trier of fact, which in a jury trial case is the jury, may return a verdict on one or the other of the charges, but not both. That's a specific plain language that refers to the jury.
That's the same principle in double jeopardy. If those cases are reversed, it's because both crimes can't stand together. Here, it's more or less the same thing. We have a statute, but it's the same principle.
Well, and I think the statute is the key. That makes it a distinct situation, distinct from a double jeopardy analysis.
So let me explain to us what would happen if we follow your theory. This jury has already said that the state proved all the elements of both, let's see, this one is petty theft and dealing in stolen property, correct? So when we go back, if we say that you're entitled to a new trial, the defendant would again be charged with petty theft and dealing in stolen property, correct?
Correct.
And so then what from there? What happens? The jury gets to hear all of this evidence again, and then what do you do once the jury's heard all this evidence?
Then the jury should be told that it has to decide between one or the other charge. It has to decide whether the defendant is more of a thief than a trafficker or more of a trafficker than a thief. And
how far would that go? I mean, would we, as Justice Labarga was just talking about, would we then tell the jury that despite the fact that you found that the state has proven both petty theft and dealing in stolen property, that you are only to find the defendant guilty of the greater offense? Is that what you are suggesting we tell them?
No, Your Honor. Suggesting that they make the decision based on the facts. The Supreme Court Committee on Criminal Jury Instructions has proposed an instruction that tells the jury they have to choose one or the other, and it explains the difference between theft and dealing in stolen property.
But how do you, but let's assume that again the jury feels that the state has proven both that there was a petty theft by this defendant and that this defendant deals in stolen property. How does the jury, what is it that we tell the jury so that they can decide on which one to convict the defendant of?
Well, in Hall, this court distinguished between theft and dealing in stolen property based upon the defendant's intended use of the property. So the jury,
what? I'm sorry.
Intended use of the property.
Okay.
So the jury would have to, as I said before, make a decision whether the defendant was more of a thief than a trafficker or more of a trafficker than a thief.
Well, so on that, what if the jury decides the person's both a thief and a trafficker? You know, is it? And I have to look at this standard jury instruction. Unlike the lesser includeds, is the defense allowed to then argue based on the statute that even though both can be proven, the evidence in this case shows that they're more of a thief and therefore you should convict of this offense?
Sure.
Does the jury know which is the lesser and greater offense when it comes to these two, unlike, you know, where you do the lesser included?
No, the jury doesn't know. Not told that, no.
And neither the defense or the prosecution can say which is the greater offense?
No, and the
cannot
jury
say
can't be
that.
told what the penalties are.
So there was nothing that this jury had to know that this, by statute, not by express statute of the legislature, that they could not convict of both offenses.
No, they were instructed on both offenses, given verdict forms for both offenses.
Would it make any difference to your analysis if the conviction in the case was derived by a guilty plea as opposed to a jury verdict?
No, Your Honor. I mean, in a guilty, Hall was a nolo contendere plea.
No contender plea.
And
What
in that
about if a
case-
jury came back with a verdict? Would that make a bigger difference?
I'm sorry, I'm not understanding.
Because say the
question.
jury heard the evidence in the case, and they came back because they were given no choice, found them guilty of both charges.
Correct.
Would that be a better argument for you that a jury should retry the case because they heard the facts as opposed to the defendant pleading guilty to a judge? You follow me?
Well, if it's a jury trial, yes, the jury should be the one that makes the decision.
Right.
And in a plea case like Hall, the trial judge would make the decision which crime better describes the defendant's conduct.
You were, I mean, Hall, you use Hall to your benefit in that if our view was that you should find the person guilty of the greater offense, we would have just directed that occur? Is that how Hall helps your?
That's correct.
Your argument?
What Hall means is the court found that the statute applies to pleas, and that when a trial court is presented with a defendant who pleads to both crimes, the court said the trial judge must make a choice. And the court said, just as a jury must make a choice when the defendant goes to trial, the trial judge must.
In your mind, is it possible, given the statute in place, that a person could be convicted of both dealing and stealing? Example, I break into a house and I steal a tape deck. Take it home. My intention is to use it for myself. I'm going to play that tape deck. A week later, a month later, I get tired of it. I take it to a pawn shop. I need $20.
Right.
Now, has there been enough time between both crimes that both crimes could exist, given the statute in place?
I guess that would be a factual question for the jury, whether it's one scheme or course of conduct.
Right. But in a guilty plea, isn't that something that the trial judge could have taken into consideration in accepting guilty pleas on both charges?
Sure. The trial judge would be the fact finder and would make that decision.
Right. So there will be no need for there to be a new trial if the judge made a factual finding.
In a plea case.
In a plea case.
Yes.
Okay.
And you know, Hall also is interesting to me because in addition to being a plea case, I believe Hall is also a grand theft case.
Right.
As opposed to a petty theft. So does it make any difference? I mean, and they said in Hall, the conclusion is you send it back to reverse one or the other. And so grand theft is a felony, and I'm not sure which degree felony it was in that case, but also dealing in stolen property. Whereas in this case, we're talking about petty theft, which is a misdemeanor, and dealing in stolen property, which is a felony. So does it make a difference, the fact that we were dealing with two felonies in Hall, and therefore the trial judge could pick one of the felonies, whereas here we're talking about a misdemeanor and a felony?
I don't know that it makes any difference to my argument. I think it may have been, thinking like that may be important to understanding the policy behind the statute. And that is, someone like my client could be convicted of a second-degree misdemeanor theft and yet be exposed to a sentence of 15 years for a second-degree felony.
But, you know, if you look at this in the whole context of the criminal statutes we have, I mean, it seems to me in other contexts, the legislature has made a point of saying that people should be convicted of the highest offense that the evidence will support.
Right.
And so why wouldn't, under these kinds of circumstances where you're talking about petty theft and a misdemeanor and stealing of stolen property, a felony, that the instruction shouldn't say the highest offense for which the state has proven its case?
I don't know the answer to that, Your Honor.
Maybe the answer actually is, if the legislature has said that in other contexts, if the we're following here. We're endeavoring to follow legislative intent. When we deal with double jeopardy, we're having to necessarily interpret it through the lens of the Constitution. This isn't a constitutional argument, correct?
Correct.
It's a statutory construction argument.
Right.
So if it would be very easy if the legislature had said in the statute, and maybe they'd like to do that, to say that the jury is then, if in circumstances where the jury finds them guilty of both, that the judge shall impose the highest degree felony that is found. I mean, that would be, you could not, if that happened, you couldn't find an argument to say, no, they couldn't do that. You agree?
No, if that's what the statute said, that's what would have to happen.
So going back to this case, though, in terms of what was argued and what occurred, this is unlike the other case from this morning. Nobody asked for an instruction.
Correct.
What is it that the defense lawyer argued as the reason the jury shouldn't find him guilty of one or the other? How was it argued to the jury?
The main argument to the jury and to the court in the JOA motion was that the evidence was entirely circumstantial, that there was...
as to what? As to whether he was the one that stole the property?
Correct. Well, the jury acquitted him of burglary. They found him guilty of the theft and the dealing in stolen property. The argument was that basically...
Was he an employee of the...
No, he lived in the neighborhood. That the inference of guilty knowledge arising from the possession of recently stolen property was not sufficient, and that Mr. Blackman had presented a reasonable hypothesis of innocence, which the state had not factually rebutted. And so the argument to the court and to the jury was that
he wasn't guilty of either crime.
The state had not proved its case.
So how would the jury, and maybe this goes to the question whether it's fundamental error and to not instruct the jury. We're not talking about what the remedy is, but whether it's, how would the instruction have changed how this defense would have been argued in this case?
Well, I think the defense could have taken alternate positions.
But there is, maybe there was a strategy reason why the defense lawyer didn't want the instruction. I mean, again, the second case is different because it was requested and it wasn't even allowed to argue it. But in your case, where's the, it doesn't, to be fundamental error for the jury instruction, not for what happens afterwards.
Correct.
Doesn't it have, how is it fundamental error in this case?
It's fundamental error for two reasons. One is because it's fundamental error for a court to fail to enforce clear statutory intent.
But why can't that be done by, going back to what Justice Quince was saying, why can't that be done in this case? Because there was no attempt to say, find him guilty just of the petty theft, to say that the judge can make the decision based on the facts as presented to the jury to decide which offense should be imposed. Why, you know, they have the factual record.
Because the judge in this case was not the trier of fact, and the statute specifically refers to the trier of fact. Before I get too far into my rebuttal time, I'd like to mention argument 2. I raise this argument because Mr. Blackman's convictions and his violation of probation are solely based on the inference of guilty knowledge that arises from the possession of recently stolen property. I just want to emphasize to the court that in a circumstantial evidence case in general, and in this particular case, the state is required to rebut a reasonable hypothesis of innocence with facts. And the state has presented no facts which rebutted Mr.
So the reasonable hypothesis of innocence is that Mr. Blackman saw these pipes in the lying someplace, and that several hours later he came back and they were still there, and so that's when he took them.
Right. He found them by the side of the road near his home, and the next morning they were still there, so he took them to the junkyard.
Now, doesn't a reasonable hypothesis of innocence have to be reasonable?
It has to be reasonable. But the way the court determines, the way the trial court determines on a JOA motion, or the way the appellate court determines that, is whether there are any facts rebutting that hypothesis.
No matter how ridiculous it might be. I mean, can it be, is it a reasonable hypothesis of innocence if it's ridiculous, that one would do whatever the actions are?
Well, I would say if it was totally laughable, perhaps
it
not.
is somewhat laughable that someone would go to the extent of burglarizing this business and take the pipes and then just decide they're going to leave them as refuse on the side of the road. I mean, people don't ordinarily steal things and just leave them on the side of the road. That's a quite extraordinary circumstance.
Well, and I would say, Your Honor, that that's not a fact. If that is speculation, and that people do all kinds of silly things. And I'll reserve the remainder of my time. Thank you.
One more question. Did your client testify?
Yes, he did.
And was he impeached with any prior convictions or things like that?
He had prior convictions. His story, his reasonable hypothesis of innocence, was not impeached by any facts.
No, but he was impeached. So the jury could consider his prior convictions as impeachment on his credibility.
Correct.
So the jury can make a decision. Isn't that a fact-finding question on the part of the jury, whether it's reasonable or not based on his credibility?
That's part of their decision, but I would submit that when the defendant presents a reasonable hypothesis, the state is still obligated to present something that contradicts it, like a prior inconsistent statement or something like that. Thank you.
May it please the Court. Jay Kubica for the State.
Before you get into the main argument, can you just, the defendant was charged with burglary?
Correct.
The jury found him guilty of petty theft?
Correct.
What facts would have supported that, since these pipes were inside a business?
It was. Well, it was inside the fenced compound of a business.
It was where?
Inside the fenced compound of a business.
That to get these out, you wouldn't have to have burglarized the establishment.
Assuming that the jury felt there was enough evidence to establish burglary in the first place, they could have felt there wasn't enough evidence that this specific individual burglarized. He may have had a co-conspirator that helped him out, and while he was part of the theft, they may not have felt he was tied into the burglary enough to find him of that. Of course, wondering why a jury is acquitted of any given crime involves a lot of speculation.
Well, that probably leads to the question of, since we know that juries are, they're the finders of fact, and we might end up finding differently on a particular crime, that we give the jury proper instructions and then we leave it to them. So I certainly appreciate that as the second point. But leading to the first point, which is that there's a statute that says, jury, is the trier of fact, you cannot convict of both of these offenses. This isn't and judges have not been instructing on this because we don't have a standard jury instruction, which is now being proposed. What is how in the world, if the jury doesn't know that they're not supposed to convict of two separate offenses, can the jury have been properly instructed on these two crimes?
Well, as an initial matter, the state agrees that the jury should be instructed. And as you pointed out in this case, there was no request for an instruction. That cannot be fundamental error. But in terms of knowing which one the jury would have picked, looking back, that is one reason we apply the double jeopardy analysis, because we do not.
Except that, I don't understand, say, why they found him guilty of petty theft. How do we know that the same jury, and this is what Judge Klein, I think, wrote in a concurrence, wouldn't have decided on the petty theft if given a choice that he's, more of a thief than he is a serial fencer? I mean, it's certainly a big difference in 15 years versus for petty theft?
It would be 60 days in the county jail.
So how do we know what the jury would have done, without having been instructed according to what the legislature has told the judicial branch is to be the way that these two crimes are to be presented to a jury or a fact finder?
And I think what you said is the key. It's what the legislature has said. And in this particular situation with 812.025, it has been interpreted and applied fairly consistently for over 30 years by the courts of Florida. It has been applied that when the jury is not instructed, we apply double jeopardy analysis because it is a kind of statutory double jeopardy, and it is the same principle as double jeopardy. And
is there any other statute that does something like this? I'm just not familiar with it. Anything else? Is this unique in the statutory scheme?
There is none that I'm aware of. As the Williams opinion says, it is a rare, if not unique, form of statutory double jeopardy. It is important that...
But wouldn't the easier thing be, and maybe it will happen if, for the legislature to say then that if the finder of fact erroneously convicts of both offenses, that the trial judge shall convict only of or vacate the lesser and leave the greater, that's our intent in accordance with our instructions?
It would be, and they impliedly have, because for 30 years the courts of Florida have applied that exact remedy to vacate the lesser. The legislature is deemed to know how the courts are applying its laws, and it is deemed to agree with the court's interpretation and application of those laws if it takes no action on that law afterwards. And for 30 years, since 1977, this statute has been unchanged. And Ridley, of course, was the first one in 81 that applied this remedy, and it still wasn't changed. Now, I think part of the confusion about 812.025 is the language. It says, if you have theft and dealing, you can charge both in the same information, you can try both, you can consolidate them for trial, but you can only come back with a verdict on one. Paul talks about, in general, the legislative intent for the Anti-Fencing Act as a whole, and 812.025 was one statute passed under that. And it talks about the intent for the theft statute, which is 812.014, and dealing, which is 812.019. But Hall does not talk about what the actual intent for 812.025 was. The legislative history of 812.025 reveals that it comes from a footnote in a law review article that talks about the principle that when you have someone who has stolen something and they have also received those stolen goods, it may be necessary to try them both, but you can only come back with a verdict on one. And that is almost exactly the language of 812.025, with the exception that the principle deals with receiving and theft, whereas...
I may be stepping on the next case of Stowe's here, asking you this, and I hope I don't get you in trouble. But are you opposed to the jury being instructed in the front end?
Absolutely not. We think that is the correct course, and if I recall Ridley correctly, that is what Ridley says. Ridley says you should instruct the jury, but the question is, if you don't, what do we do? And the state agrees. The jury should be instructed. But the issue that we have now is, what is the remedy? And the remedy has always been in Florida, that we vacate the lesser, because this is analogous to double jeopardy, and the same principles apply. We have to, at the same time, respect the spirit of 812.025, that we can't have...
If in the grand, this is a petty theft, but in the grand theft analogy, if the grand theft and the dealing in stolen property are the same degree of offense, how do you make a decision? Just pick one.
For the jury to make a decision?
Or, no, in a situation where they've been already convicted and sent back to the trial judge to make a determination. The trial judge just makes that determination based on, well, they're both, felonies, so I'll just pick one and reverse that one?
You mean in a situation where they are of equal degree?
Yes.
Even when you have a grand theft, say a second-degree grand theft, and you have dealing in stolen property, which would be a second degree, you're still going to have different offense levels. The one will be higher than the other, and the judge can use that to vacate. Based on the criminal punishment code.
Well, I mean, when you look at the if you look at the criminal punishment code, that you're saying that's what you do. You go back and look at the criminal punishment code and determine under that standard which of these would get the higher sentence?
If you find yourself in a situation where it's second-degree grand theft. Now, of course, the vast majority of these are going to be third-degree grand theft, and dealing in stolen property is going to be either second-degree or first-degree. It is even rarer for there to be a first-degree grand theft combined with dealing, but theoretically, they could occur.
Let me take you back to the double jeopardy, because I'm having some, and trying to think about it as I was reading this. The reason I believe, and correct me if I'm wrong, that in double jeopardy we basically allow the trial judge to pick the highest offense is because the evidence believes that that's what the state proved, the highest offense. But in double jeopardy, the reason we don't allow a conviction for both is because one crime pretty much merges into the other. No, one crime is encompassed by the other. The two cannot coexist legally. Here, the two crimes can coexist, but for the statute.
Correct.
So I think there's a difference there. I'm trying to put my finger on it. Maybe you can help me.
I hope I can. That is why we call it a rare form of statutory double jeopardy. It is not double jeopardy in the constitutional sense, in the sense that one crime would really go right into the other, but it is double jeopardy only because of this statute. And I think, going back to your question about, he really is guilty of both offenses, and you can have that, and it's logically consistent, and the jury has found that, and we do have to respect both of those verdicts, which have no infirmity in and of themselves.
Well, they do, but except the problem is there is an infirmity. The infirmity is that the legislature has said fact finder, not sentencing judge, you cannot convict of both offenses. So the jury, without knowing, they're violating the legislature's direction that they can't do it. So despite the fact that you in answer to Justice Labarga's question, you went back to say this is a form of double jeopardy. It's not a form of double jeopardy. It's a form of the statutory, clear statutory direction.
The only infirmity is not in the convictions themselves. It is because
maybe that's where I'm having trouble. I thought the infirmity really is with the conviction because, especially, are you going to be the next case? Are you on that?
No.
Oh, too bad. Because I'm really interested in what the instruction is going to be going forward. I mean, obviously, we care about how to remedy this, but to me, the more important thing is going forward is what's the proper instruction for the jury. So that you agree that if requested, instruction must be given to the jury that they cannot convict of both offenses.
Absolutely.
But in double jeopardy, when that happens, and it's rare it happens because there are very few double jeopardy offenses anymore, that the jury isn't told, you have a lesser offense. They're not told about to do the Blockberger analysis. They don't do that, correct?
Correct.
So what would be the proper instruction for the jury? They're told, first of all, if it's not part of a common plan or scheme, then they could convict of two different offenses, right? If there's if they tried them together, but there's a theft at one point, but then as part of something else, they're doing fencing, right?
Correct.
Okay. So the jury first has to decide it's part of the common scheme. Then what is it that the jury is then told about? You're going to find them guilty. Here are the elements, but you can only convict of one. Is the standard jury instruction that's being proposed, does the state support that, or are you not in a position to give us the state's position?
We do not support the instruction that's being proposed. What should be proposed is the language of the statute, because that
just saying that, just telling the jury, don't convict of both.
Correct. And
that would be a simple solution, which is that's as much as the legislature said. That's as much as this court, a judge should be telling them.
Correct. The problem with the proposed instruction and the problem with Hall in general is, and I point out that it's a plurality opinion and do that kind of deference, it takes language from the intent of the overall Anti-Fencing Act. It does not go to what the actual statute 812.025 is talking about. And in that manner, it cannot be accurate in terms of what the legislature wanted the jury to make a decision on.
So we would just leave it to the jury to make a decision as to which of the offenses, even though the state may have proven both of them, if the jury, for whatever reason or no reason at all, decides that petty theft, will convict him of petty theft on this one, and that's fine. But, you know, a jury with similar kind of facts, if they decide to convict him of dealing in stolen property, that's fine.
Correct. Now, I'd like to point out that one of the dangers of what the defense is asking for is maybe this wouldn't hurt Mr. Blackman, but as things stand now, as they have stood for the last 30 years, the state could go to trial on both dealing and a theft charge, and the state could at least know that, you know, I'm only going to take one away from this, but I'll get the highest of whatever the jury gives me. The defense, on the other hand, has a benefit as well. The defense can roll the dice and say, well, I might actually be guilty both. There might be enough evidence to support both, but the jury can always pardon me on the higher. So I might get the theft or the dealing, whichever is lower. What's going to happen is if a new trial is the remedy rather than the vacation of the lesser, is the state is not going to let the jury make that call anymore. The state is going to go forward on the higher, and the defense is actually going to be losing out on at least one kind of a pardon opportunity.
Maybe, or, I mean, and that, there could be an affirmative waiver, I suppose, of the instruction. If they, I mean, there's lots of things that could happen. I guess going back to your, and you've obviously given this a great deal of thought, I appreciate that, and how you've approached this whole argument. What is the, do you disagree that it's fundamental error to not have given the instruction in this case?
It is not fundamental error to not have instructed in this case.
And the reason being?
It was never an issue in trial. As I believe Your Honor said, the defense's theory was all or nothing. It wasn't one or the other. And if it goes back for a retrial, that theory won't change.
But that would be something unique to this case. But does it necessarily mean that, because I haven't looked back at the Fourth District case, were there different factors there, or would we necessarily have to disapprove of KISS if we go with what you said, which is that it wasn't the way this was argued, so therefore it's not fundamental error here for the jury not to have been instructed on it?
I don't believe that the opinion in KISS discusses what constitutes fundamental error in instructing a jury. I believe KISS just kind of mushes everything together in terms of we've got two convictions and there
But
was.
they don't discuss what was being argued by the defense in terms of the which crime should be, should they find one or the other? We don't have the facts developed in the opinion.
I believe we have some of the facts. I don't recall specifically which argument they were advancing, but the principle is for fundamental error in jury instructions, the instruction has to have been an issue in trial. And even when there's a failure to instruct on basic elements, what the jury would necessarily have to consider to convict someone, even that is not fundamental error when there's not really an issue on that element. And in this case, picking one or the other was not an issue for the defense. And as you pointed out, there may have been a strategic reason not to ask for it, or there may have been a strategic reason just to sit there silently, hoping that if the defendant is convicted of both, he gets a new trial and he gets to run this same defense all over again, despite two, at least individually, valid jury verdicts.
We're almost out of time, but what about the second issue that was raised here? The defendant seems to be arguing that because he gave what he considers to be a reasonable hypothesis of innocence and the state didn't do anything to rebut it, that he's entitled to an acquittal of the petty theft.
Well, as a preliminary matter, that's not the conflict issue, and I would suggest to this court...
I understand that,
yes.
But what's the answer to whether or not the state should have rebutted the reasonable hypothesis?
Well, the state, in the sense that it presented evidence that the defendant so shortly after this crime occurred was seen in possession of the stolen property and seen selling the stolen property, that in a sense puts it before the jury as an issue as to whether this hypothesis was sufficiently rebutted. It cannot be said that the defendant's hypothesis was reasonable as a matter of law. Rather, it's more like, I believe, supplemented with Wilson, it's more that it is a jury question as to whether this has been sufficiently rebutted, as to whether this is actually reasonable.
Well, I mean, if that wasn't the case, that what is reasonable or not is a factual matter, then one could say, I saw a spaceship drop them. And the state doesn't rebut that, then you would have to accept it.
I'm not sure I understand.
I mean, a reasonable hypothesis of innocence. If someone's driving down the road and says, I saw a spaceship drop the pipes on the road.
Correct.
The state doesn't rebut that, then if the jury cannot make a determination as to what's reasonable or not, then you would have to accept that.
Correct. But the jury can decide whether that's reasonable or not. What I'm saying is...
That's my point.
Yes. What I'm saying is that could not be deemed reasonable as a matter of law to grant a JOA, if I understand correctly. Rather, I mean, the defense can argue that to the jury. I would think it's highly unlikely that they would accept that, but it's certainly not grounds for granting a judgment of acquittal or finding that the state's evidence was insufficient. And the state, again, reiterating, this has been the rule of law in Florida for 30 years. It's impliedly accepted by the legislature as the way they want this statute applied. So the state asks that you affirm the judgment in Blackman and disapprove Kiss. Thank you.
I had not understood before from the state's arguments that they agreed that the jury should be instructed. But the state is arguing that it doesn't matter in this case because it's not fundamental error. For one, it is fundamental error because courts are required to follow plain statutory intent.
Yes, but he's saying that under the facts as argued, because we have distinguished fundamental error, that it might be fundamental in one case and not in the other.
But I think that looks at the error at the wrong point in time. The error is the jury was allowed to return two verdicts. The statute says the jury can't do that. The jury could not have returned two verdicts if the statute had been followed. That's where the error is.
Didn't the state in this case concede that the dual convictions, that was fundamental error? by saying that.
Correct.
They're not saying necessarily that the failure to give a jury instruction is fundamental error.
That's the distinction that they're making, is between convictions and
Well, that
between the
seems
jury
like
verdicts.
it could be that could be a reasonable distinction. It wouldn't be a reasonable distinction in the next case coming up, because obviously the instruction was requested. But if the theory is that I didn't do it at all, and it was, it really doesn't matter to that defendant arguing it. That's what he's hoping for. He's hoping that they just believe that he just found something on the side of the road, and since it was just finders keepers, he decided to, sell it for whatever it was worth.
And in response, Your Honor, I would just say that that's not what the statute says. The statute requires the jury to make the decision. Thank you.
We thank you both for your argument. The court will now stand in recess for 10 minutes.
All rise.
We now go to the third case on our docket, Williams versus the State of Florida.
May it please the Court, my name is Carol Wilson, and I represent Melvin Williams before the Court in this case, which was certified with 3 questions by Judge Altenburn out of the 2nd District. And our position is that there is no remedy other than a new trial in this case.
There is no remedy what?
There is no remedy for the failure to instruct the jury in this case other than a new trial. The first question Judge Altenburg posed was, must we instruct the jury? The State, in the prior case, conceded that it must be instructed, but I believe that the instructions that have been proposed by this Court's committee address the issues. I would disagree with some of the language, but had the jury in Mr. Williams' case been given the opportunity, and this is in the record in this case, then the defense counsel would have been permitted to argue to that jury that there are different intents when people take property.
And I want to, in contrast to the case before, the defense lawyer here specifically asked for an instruction.
Yes.
The only reason that would say that you can't convict of both, correct?
Yes.
And the judge gave as a reason that he agreed, that's what the statute said, but that he couldn't fashion a jury instruction. That was his reason.
That was his reason that was stated. That was part of it. There were a lot of things said.
And then because of that, the defendant was not able to argue that they only could convict of one.
That's correct. That's very plain in this record.
So how is it, I guess it's the question, I don't know how under these circumstances it's not reversible error. But that's what you would agree. Now, but are you going to, and what's the next question? If we agree with you that instruction should have been given and it was reversible error, what's the next, or does that end it if we say it should have been given and it's reversible error that it wasn't given?
Then it needs to go back for a new trial on these charges.
So how do we answer the rest of the questions then?
Well, the rest of the questions pertain to should the instruction be given? Yes, the instruction must be given. What's the remedy if must the trial court order a new trial if the instruction is not given? So the question first is the instruction required? I think the statute is plain. The instruction is required.
Okay. Now, but do you see, and I realize you don't want to throw somebody else under the bus, but do you see any difference between a case where a defendant affirmatively requests the instruction and is prevented from arguing something based on the instruction, and one where the defense doesn't ask for it? I mean, this has been a statute on the books for a
almost
long
35
time.
years.
How many? 75?
Almost 35 years.
35 years. And their strategy is such that they're saying, it wasn't me at all. So really, I'm not guilty of either crime. Is it always fundamental, and maybe you don't want to answer that it's got to be given, it's always reversible error if it's not given?
I don't think there's a per se rule issue here, certainly not in my case.
Okay, so you
and I don't know that this court ever
facts.
considers cases. I think part of the confusion that arose with this whole problem to begin with is that courts decide cases based on the issues that are presented to them. They don't decide cases based on what courts have done for 30 years. This issue is recent in having arisen the way that it's been presented to the courts. It's a recent issue, although the judges have resolved it, as was done in Hall. But now, this specific issue has been raised mainly through the Fourth, through Judge Klein and Judge Halzuri, saying we need an instruction. And then that request was answered by the court's committee. An instruction was forthcoming, but it was too late for these cases before this court.
Well, let me ask you about the instruction. Here,
Yes, sir.
there was a request for an instruction and actually the language for that instruction. But was that instruction enough? I mean, was the trial judge really incorrect in not giving that particular instruction, because it just leaves, basically says what the statute says, which is you can't convict of both the theft and the stealing and stolen property, correct?
Yes, Your Honor.
That's what the requested instruction said.
Yes, Your Honor.
And so, without going any further, is that a correct instruction?
The instruction that the defense attorney fashioned was basically based on the language, but she also gave the trial court, and the trial court stated in the record, I have the language about the intent in Hall. And then if you look at the record, I believe it's on page 36 through 37 of the proposed instruction, where she cites the language of the statute, and then she cites the language from Hall that refers to the intent language, which is what's key in the proposed instruction.
But is that what she, I mean, you're saying she asked for both? Because I thought I read it as she just asked for an instruction that actually talks about the not convicting of two. But she also asked about...
During the discussion, my memory of the charge conference, you have the memo, a special instruction in the record, and when the judge is saying this is too difficult for the jury, it'll confuse them, then she says, well, there's also this language in Hall, and he says, yes, you have referred to that. And in that, what she's quoted on the record on page 36 is, the state can charge both, but then the fact finder must determine whether the defendant is a common thief who steals property with the intent to appropriate said property to his own use, or whether the defendant traffics or endeavors to traffic. And that's the key language that we believe the trial court was apprised of in this standard instruction. And therefore, we believe that the instruction as a whole apprised the court of the error and allowed it an instruction that could have been fashioned that would have been similar to the proposed instruction by the committee. Now, it may not have been perfect, but we had the situation where we have nothing, and that the defense was then foreclosed from making any argument whatsoever. And that in that situation, in this case, where Mr. Williams was arguing the state did not prove that I committed these crimes, that the defense was then foreclosed from saying, well, the state's proof was that none of these crimes were committed, the fingerprints wasn't his, but also if, the alternate defense theory would have been that there's not the intent to traffic here. So find him guilty. If you find that they've proven that he did commit any crime, find him only guilty of the theft.
Just so I'm clear, are you opposed to the proposed instruction by the committee?
I'm not opposed to it. I myself would write it a little less specifically because the statute is more general. It doesn't say it has to be the same property. The statute says it just has to be a common scheme or course of conduct. And so there might be a problem with the instruction by narrowing it. There could be an argument made that narrows it beyond what the statute provides. So if I were on the committee, I would broaden it to reflect the statute in a manner that I don't think confuses the jury at all, because they're making an intent decision here, which jurors make all the time in a jury trial. And I believe that if that kind of instruction had been given in this case, then Mr. Williams his jury would have been able to make the proper decision under the statute that's been on the books for a long time.
Going back to the topic that we discussed in the previous case, I saw you were sitting here. So this whole double jeopardy analysis, and I asked the question because I'm having trouble with that. Double jeopardy is a constitutional prohibition against a person being prosecuted for the same crime twice. And some crimes merge into other crimes, and therefore double jeopardy prohibits conviction for both. In this instance, both crimes can stand. One can be convicted technically of both crimes, petty theft, grand theft, and dealing. It's just that the statute says you can't do it. So there's a difference there in rationale. Do you see that as in any way impeding applying the double jeopardy rationale to these type of cases?
I don't think that it's because it's a statutory construction that really is at the heart of this case. It's not, double jeopardy is separate, and double jeopardy can, the statutes may be applicable in deciding the elements. But here you have this unique situation where you have two separate crimes, and you have the jury has to decide between the two of them, and it's not a legal decision, it's a factual decision. What intent was involved in this common scheme or course of conduct? And so that is a very much a jury question and very much a factual question, which is completely separate from the legal question of double jeopardy.
What are the parameters of the one scheme or course of conduct? I assume that hijacking a tractor trailer of cigarettes and then selling them, that's pretty clear. It's all compact. But what are the other boundaries of this? It just seems that this circumstance could be limitless, really. Youngsters go and break into something, and then they use it, and then piece by piece they do something with it. What defines one scheme or course of conduct? What limits it? What expands it?
Well, I think it was shown in the facts of this case, Your Honor, because the state chose to charge, and then the judge instructed the jury on exactly the same items that were taken were the same items that were trafficked. And the confusion that maybe arose in this
Even though there were some others taken as well, right?
Actually, what was charged and what was instructed was exactly the same property.
Really?
It's just that the proof itself, there was a variance.
Okay.
So as this court often does, it looks at the charging document to make decisions, and that's how this case was charged, and that's how this jury was instructed. And so we think under the facts of this case, it's a common scheme because that's how the state chose to charge it. Now, there will be other cases that could be presented to this court that would present other questions, and I certainly can't answer them, and that's just the nature of what we do.
It's going to end up being a case-by-case application with a mishmash of what is and is not with all the district courts then, huh?
Well, and there's questions, I think it's like with the what's going to be the question about what's a circumstantial evidence. There's going to be, as a matter of law, what's a common scheme and course of conduct. And some of the cases have already developed along those lines in deciding whether there was both crimes applied. So there is some case law out there. I don't think it's as strict as it's got to be on the same day. I think that there's going to be a number of factors that are going to be taken into consideration. You're going to take time. You're going to take where did this property come from. You're going to take the volume. I think there'll be a number of things that this court would take into consideration. But it's a factual decision that the jury should make.
Let me ask you about the proposed jury instruction.
Yes.
One of the things that concerns me is the second paragraph, which talks about then you would only find him guilty of theft, and it says, we'll find the defendant stole the property with the intent to appropriate the property to his own use. You should find him guilty of theft only. But if he intends to traffic in the stolen, the next one, if he intends to traffic in it, then you find him guilty of dealing in stolen property. Because they use here with intent to appropriate it to his own use, where does the situation fall where you steal it with the, I'm stealing it because my sister needs whatever it is that she may need, so I'm going to steal it. Does that put it in the trafficking portion, or is that a theft?
I believe that's a theft because it says for your use or for the use of another.
So this instruction, would this instruction need to be tweaked to include that?
I agree, it would, because I think if like in this case, there were kids' games that were stolen, so you could say, I'm stealing this from my nephew or my child, but I'm not going to play Nintendo. I think that situation.
No, I just wondered if you pass it on to someone else, if that constitutes trafficking as opposed to just a theft. That was my question.
I don't believe so under this court's language. I believe this court's language in Hall, because it's not just the person's use, it's or for another, but for personal use. Because when you're looking at who's going to be the trafficker, who's going to be the fence, that's a middleman who routinely takes items that he knows are stolen, and that's how he makes a living. And so the jury needs to, so that anti-theft law that's trying to get at that middleman in order to reduce that kind of a crime and to punish that person more severely is very different from just the common thief. And that's the distinction that the jury is permitted and required by the statute to make from, among these two crimes. And if I could just reserve my 5 minutes.
I'm sorry,
no,
another
please.
follow-up question to this.
Yes, yes, ma'am.
What kind of jury form? I've been thinking about what would the actual form look like that you would give to the jury. Do they have to mark, I would assume they have to mark off whether or not it is a common scheme or course of conduct, or find that it isn't a common thing, a common scheme or course of conduct?
I don't know that they would, because there's no necessary like sentencing aggravator. There are greater sentences possible, but you're just defining the two crimes side by side differently. So I think you could just have two verdict forms.
That would be an issue, because you wouldn't even get to the statute. And I know that the last part of the proposed instruction, you wouldn't even get to the statute if there is no common scheme or course of conduct. So wouldn't you have to find that first in order to be concerned about 812.025?
Right, you would. Actually, you're right. That should move up, because logically you have to decide that there is a common scheme or course of conduct. If there is a common scheme or course of conduct, then you have these two crimes that you have to decide between, depending on the intent that's been proved. So I agree with that. I would change that so it's more logical for the jury to make its decision. And I've run out. I'm running into my rebuttal time, if I may.
You certainly may reserve it.
I would like to reserve a few minutes. Thank you.
May it please the court. Danilo Cruz Carino, representing the state of Florida in this case. I'd like to begin by addressing the fact that upon further review and reflection, we do believe that the better policy here would have been for the judge to essentially have given the jury instruction. However, I think it's important to note the trial court, really the standard of review here is abuse of discretion, because what we've got here, especially in light of the fact that this happened in 2009, what we have here is a special jury instruction that's proposed. And the judge, I think we need, in order to be fair in the assessment, the judge essentially did not have KISS. This was pre-KISS. Also, he understood that there was
pre-KISS.
In other words, Your Honor, the decision here by the trial judge was in 2009, and KISS came out in 2010. So in other words, he never had before him that. Again, we're going back to the case.
I was thinking of Ridley, which is the 81 case.
That's correct, Your Honor.
Okay.
That's correct. But Ridley is addressing the remedy, and quite frankly, that is exactly what the trial judge here did. He was consistent, again, going back to our previous case in Blackman, the judge here was consistent in the treatment, looking at 30 years of jurisprudence that has been dealing with the issue of the remedy being essentially...
But was there a request in KISS for jury instruction?
Don't believe so, Your Honor. There was in ours.
So let's make sure I understand. I think that you are saying if a case is to come up next month where a defense lawyer or requests the instruction that they can only convict on one, that the judge doesn't have discretion to say, no, I'm not giving this instruction, does it seemed like you were saying something about that the judge's discretion was, let me finish my question, that the judge's discretion was appropriate because the judge didn't have a standard jury instruction? Is that what you're saying?
No, Your Honor, that is not what I'm saying.
Okay,
what I'm saying is that there was no abuse of discretion in not granting the special jury instruction. Now, I want to make clear...
But you do agree the statute says the trier of fact, in this case with a jury, should not convict of both crimes, and that in this case the defense was expressly precluded from making the argument to the jury.
Yes, Your Honor, but the defense was not based on the statute. His defense was, honestly, I didn't know that the items were stolen, and I just happened to stumble upon them, and I took them to the pawn shop, and that's how you have the video of me and my fingerprint, and that's how I pawned these items. Well, his defense was not based on the statute. And so what I am arguing, and I want to make clear before the court, was it error in this case to not give the proposed jury instruction? Well, I would argue yes, but it was not fundamental.
Oh, wait, you do know. I know. Okay, so you've agreed it was error. But fundamental error is not what we employ when an instruction is given. The standard of whether an instruction was erroneously refused is whether it is whether there is any basis in the law or fact to give the instruction. So once it's given, your only way to go about it is that you would argue it was harmless. You'd have to argue, not fundamental error, that it was harmless error beyond a reasonable doubt. The state, as the beneficiary of the error, has to establish that. Now, if a defense lawyer or a defendant is not permitted to argue that even if you find this existed, that you cannot convict of both crimes, and at the most he was somebody that this wasn't his course of conduct, he's not a fencer, at the most he's a thief, how can that not be reversible error?
Your Honor, with all due respect, that was never the defense proposed at trial. His defense was never, I'm one or the other. His defense was, I'm neither.
You did say fundamental error. You agree it's harmless error?
It's subject, not fundamental, subject to a harmless error analysis.
And
that's correct.
Who has to establish harmless error?
Well, Your Honor, we have the burden, and we welcome that burden. We believe that in this case, the facts show that the error did not vitiate or corrupt the entire trial.
Now, guess what? That's not, you know that vitiate or corrupt the entire trial is fundamental error. That's not the harmless error standard.
Your Honor, if you look...
Do you agree with that?
Yes, Your Honor, yes. I would agree with you, but I think it's important to point out the defense at trial was never, listen, I'm entitled to the statute and to this instruction pursuant to the statute or tracking the statute because I'm defense, I wasn't the thief. That was never his defense. And so therefore...
Do you agree that vitiate or corrupt the entire trial is not the standard of harmless error?
Yes, Your Honor.
What is the standard? What is the DiGuilio standard?
Well, Your Honor, we'd have to prove that beyond a reasonable doubt that it didn't.
That it had no effect.
That no effect.
How and you're familiar with Judge Klein's concurrence and the whole notion that a jury, we don't know whether this jury would have convicted of the anti-fencing. How do we know that?
Your Honor, and our contention is we don't have to know. We know that the jury here essentially found that the defendant committed both offenses. Actually here, 4 offenses, the burglary, as well as the pawning, the false information to the pawnbroker, as well as the dealing, as well as the grand theft. The grand theft here was a 3rd degree. The dealing was a 2nd degree. And I would answer that question, Your Honor, we really don't have to speculate. We don't have to get there. I think you look at this record and you see the evidence, and it is overwhelming. Your Honor, if I may, a quick review of the evidence. Appellant, or a petitioner in this case, burglarized a home during the day. He stole 2 game systems, he stole video games, he stole many DVDs and a camera. His fingerprint was found inside of the home. Same fingerprint that was shown the very next day at the Cash America pawnbroker store. By the way, we also have a video, and we have an eyewitness testimony saying, that was the guy. He was the guy that came in and said, these are my things, and I hereby want to sell these things. So he was, in this case, both the thief and the trafficker.
And doesn't I guess the issue is that the state is still stuck with the legislature having said, but you cannot convict. you cannot convict of both.
That's correct, Your Honor.
The jury is given, as the finder of fact, the option of finding one or the other.
That's correct, Your Honor. And so our contention is that the leading issue here is really the remedy. Our contention is...
No, let's not stay with the... We've got to stay... See, the other case involves a remedy. Your case involves an issue as to whether the state has proven that it's harmless error beyond a reasonable doubt. We don't get to the remedy if the state can't establish that.
Your Honor, our contention is that we have, that the corpus of evidence, when you look at all the evidence before this court, it does show that the fact that the trial court did not instruct as to choosing one or the other, that in and of itself could not be cured by the remedy imposed by the trial judge.
So you're saying that a jury, every time given these same facts, will always convict of the anti-fencing and never convict of the theft? Is that what that would be? Have to be your proposition?
No,
so we really oughtn't give it to the jury to begin with. We ought to say, I mean, that's where I'm having my problem. In other words, I might agree that the legislature, if they wanted to say, but if you find both, you should convict of fencing. I mean, you know, they could say that, or they could do what they do in every other case, which is allow conviction for both, and it wouldn't be a double jeopardy problem. But we're faced with what the legislature has clearly stated, and that's where I'm just not sure I understand how you get around the harmless error.
Your Honor, I understand. Well, I guess what I'm saying is the following. We've got 30 years at the very least of case law where the legislature, if they felt for one reason or another that what they meant was some sort of windfall for the defendant to, if convicted of both, that you somehow get into the remedy, that you somehow are entitled to only be convicted of the lesser, they would have corrected that, but they have not. And they haven't because the remedy applied in this case, consistent with how it's been over the last 30 years, respects the jury's determination that the state met its burden to prove the greater offense. And so to say... But
it seems to me to follow your argument to its conclusion means that the fact that he requested an instruction in keeping with the statute means nothing.
No, Your Honor.
If he ends up with the same remedy that everyone else gets who never requested an instruction.
No, Your Honor. What we're saying, with all due respect, what we're saying is that it was in this case, it was error to not give it because, quite frankly, reviewing even the proposed jury instruction by the committee, probably the easiest thing to do is, quite frankly, to give a jury instruction that tracks the statute of the language of the statute. And so I will admit that it was error for the judge in this particular case not to give it, but then we get to, okay, does that in itself entitle him to a new trial? And our contention is that it does not. It does not. We've got sufficient evidence here that shows that, quite frankly, the remedy that was applied by the trial judge was the proper remedy. There's no entitlement to this windfall that if the judge doesn't give this particular instruction, then you essentially are given a new trial because a new jury would not convict you of the greater offense, when in essence here we have a jury that found that a petitioner committed beyond a exclusion of every reasonable doubt the greater crime, the greater offense.
That's in any of them, whether they ask for an instruction or not. We have the same thing. The jury has convicted them of the greater and the lesser offense.
Which is why, Your Honor, we're arguing that it is analogous. This is essentially, and this is the uniqueness of the statute, this is essentially akin to statutory double jeopardy. And although not the same as far as a constitutional prohibition, it isn't, but the analysis is the same. And it is the same because essentially the intent of the statute is to prohibit, as long as they're arising out of one scheme or course of conduct, these two crimes, then it is intended to prohibit the conviction, essentially, of both.
You're asking us to follow the rationale of all the DCAs except for the fourth, basically to throw out the lesser and leave in the
I am, Your Honor.
greater crime. That's what you are.
Yes, Your Honor.
Is there a difference? Should there be a difference in doing that if between a guilty plea to the court and a jury trial where a jury made factual findings as to both crimes have been proven?
Well, Your Honor, you alluded to earlier that the fact that in a guilty plea is the judge making that decision. And, you know, one of the things that I think we want to remain consistent with is the fact that the statute essentially, in this post-Blakely, post-Apprendi world, we don't debate or dispute that this is a fact-finding decision, that it should be for the jury.
What if let's say the trial judge, you're going to plead straight up to me at the trial judge, and I hear the prosecutor recite the facts during the plea colloquy, and I'll make a determination that the petty theft, or the grand theft in this case, and the dealing are so far apart from each other that both can stand. Is there a prohibition in the statute? I mean, it seems to me that the statute prohibits me, the trial judge, from doing that.
Well,
making that factual determination.
Well, not necessarily, Your Honor. I think Wilson, the Wilson case, talks about this disjunctive interval of time or a set of circumstances. And so when you can show, okay, when the facts show that there is this disjunctive interval of time or a set of circumstances, or that we don't have one scheme or one set of course of conduct, then the statute doesn't apply, and then dual convictions would not be prohibited. So that would be my answer. I think.
So how do we know that the jury didn't do that in the jury trial? That they decided that there was an interval period of time between the two crimes.
Honestly, Your Honor,
and they decided that both could stand. I mean, how do we know?
That's correct, Your Honor. In this case, we honestly don't. But I would argue, I don't think we need to go there. I mean, I think it's speculative, and I'd hate to even speculate as to what they were thinking, because I don't want to go there. But what I do want to address is the fact that the remedy was appropriate. The other thing, and that's why this proposed jury instruction by the committee, really upon further review, I think it is problematic, and Judge Quince, you alluded to this. It is that it's going to bring up, quite frankly, I think, more litigation in the future as to what is an appropriate jury form and what. Honestly, it appears to us that upon further reflection, the better approach would have been to essentially grant, specifically in this case, grant a jury instruction that tracks the language of the statute. However, I think in this case, the remedy that was applied was appropriate. And by the way, it's also.
But you know, it seems to me you can never get around, in your scenario, you can never get around the fact that this statute was not complied with when the jury is left to convict them of both of them, and then the trial judge gets to pick whichever one he or she wants to enter a sentence on.
I will agree with that, Your Honor. And therefore, I argue on behalf of the state, error. It was error because, but again, Your Honor, I think we need to review the fact that the decision that was made by this trial judge, it was made back in 2009. And I think that's very important. And he was considering the case law before him, the fact that Kiss and his progenies had not come out. And by the way, nor was any such argument made to the trial judge. You
can't have it. You've been very forthright in saying that it was error not to give it. So once you say it's error not to give it, we're not, when we say a judge erred, we're not saying the judge was a bad judge. When we say that the judge ignored the statute, we're not saying the judge is a bad judge. We're trying to give effect to the legislative intent here, which was plain that a fact finder needs to know that they can't convict of either. I don't know whether going back 30 years, those were where somebody asked for the instruction. But what I know is here, I'm not sure why you keep on bringing up that as an excuse for the judge why he didn't give the instruction. Once you've agreed it's error. So what's the relevance?
Only because, Your Honor, I think it's only fair to analyze a decision in light of the facts that were before the judge at the time he made the decision. I think it's also important
you see, if it's error, It's error. It's not, well, it's an error. We don't apply, it's an understandable error. It wasn't an invited error, which would be the kind that we would be concerned about, where the defense lawyer says, Judge, you're right, it's too confusing, don't give one. So let's just get back to I guess the best answer for why it's not reversible is because you're saying the evidence was overwhelming.
That's correct, Your Honor.
But you are familiar that in DeGuilio, it's not an issue of whether the evidence is overwhelming. It's an issue of whether, beyond a reasonable doubt, the jury would have come to the same decision if correctly instructed.
I think the facts here show that I think it would be the case, Your Honor. Yes, and I guess what I want to point out is this. And I perhaps didn't make it as clear. The defense did not pursue this instruction because their defense was based on, listen, I'm not the thief, I'm the fence here. This is not a situation like for example, let's say a high-end jewelry heist where an individual is caught. And the individual then says, listen, you got me. I didn't steal them, but I was defense. And I want an instruction based on that statute because I should not be convicted of both because I'm really one and not the other. That is not what happened here. The petitioner at all times essentially alleged there's no culpability at all. And by the way, when the trial judge asked the defense...
Does that negate... I understand. This defendant said he shouldn't be found guilty of theft or dealing or burglary or any of these things, correct?
Yes.
And that he in fact made a motion for judgment of acquittal based on that, correct?
Which was denied,
and
correctly so.
It was denied. But do those facts negate the fact that the statute says what it says? That he can't be convicted of both. No. So excuse me.
Sorry, Your Honor.
Isn't he still entitled, once he's lost his JOA motion, isn't he still entitled to ask the court to give an instruction based on the statute?
He is, Your Honor.
Well, okay.
And I guess our main contention is that in and of itself can be cured, which is what the trial judge did here. He felt, listen, I can cure. First of all, before it gets to the jury, the reality is that you don't have to have this proposed jury instruction to be in compliance with the statute. Because the reality is if the jury comes back with guilty on one or the other, or not guilty on either one, the judge would have been in compliance with the statute. And so the judge decides, as he did back in 2009, okay, listen, I think it's rather premature to proceed. And by the way, he also mentioned he thought that
the judge can't look at, we can't look at the fact that if he had been acquitted of both of them, of course, the defendant is not going to then raise an issue about the failure to give the jury instruction.
No, Your Honor.
To me doesn't make any
sense. I guess what I'm trying to say is that the intent of the statute could have been, the judge could have complied with the statute without giving the proposed jury instruction in this case.
You need to wrap it up in about 15 seconds, if you could.
Okay, Your Honor.
You're a minute over time already.
Well, we would ask, Your Honor, at this point in time that this court affirm the Second District Court's opinion and reverse only as far as disapproving on KISS. And we would also ask that this court affirm the remedy and essentially send a message that the proper remedy to be applied is the vacating of the lesser offense. Thank you very much.
I never relied on the state to make my defense for me. And if you look at the opening argument in this case on page 19 of the trial transcript, the defense was stating the state doesn't prove this case beyond a reasonable doubt. And if you look at the argument on the instructions, on page 201, the defense attorney specifically says, Judge, can I argue to the jury the difference between these two crimes so that the jury doesn't have to can't convict of both? And the judge says, no, you're not arguing law to this jury. We're not giving the instruction. I protected your record. So there's no there's never been an instance that I know of where there's been error that's been harmless when the jury has been robbed of a fact-finding function, and that's what's occurred in this case. And the only remedy is a new trial on these counts. So we ask you to quash the decision of the Second District Court of Appeals and to approve of KISS. And thank you very much for this opportunity.
Thank you both for your arguments. That concludes today's session of court. Court is adjourned.
All right.
You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.